Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study case law number 37 about the validity of property insurance contracts in case the insurance buyer pays premiums after the insurance premium expires. Including Part 1, Source of the case law, Part 2, Overview of the case law, Part 3, Content of the case, Part 4, Assessment of the court, Part 5, Rules. Adopted by the Council of Judges of the Supreme People's Court on February 5, 2020 and published under Decision No. 50/QDCA of the Chief Justice of the Supreme People's Court on February 25, 2020. Part 1. Source of the case law. Cassation Decision No. 28/2018/KDTMGDT dated June 26, 2018, the Superior People's Court in Ho Chi Minh City on the commercial case dispute insurance contract in Dong Nai Province between the plaintiff Limited Liability Company N and the defendant P Insurance Corporation. Persons with related rights and obligations comprise P1 Insurance Company, Joint Stock Commercial Bank v. S Paper Joint Stock Company. Part 2. Overview of the case law. 2. Legal solution. In this case, the insurance contract takes effect, the insurance enterprise must be responsible for compensating damages to the assured. 1. Overview of the case law. After the insurance premium expires as agreed in the property insurance contract, the insurance buyer paid the insurance premium to the insurance enterprise. The insurance enterprise didn't complain, sent no written notice to the insurance buyer about the termination of the contract but still received the insurance premium, issue value-added invoices and tax report on the payment insurance. Then the insured event occurred. Keywords of the case law. Keywords of the case law. Property insurance contract, insurance fees, term of payment of insurance premiums, validity of insurance contracts, insurance events, compensation. Part 3. Content of the case. According to the petition, the plaintiff's authorized representative presents. Limited Liability Company N, referred to as Company N, was established and operated under the Business Registration Certificate No. 3600686844 dated July 29, 2004 of the Department of Planning and Investment of Dong Nai Province, signed the 6th change on September 4, 2015. The insured, Company N, and the insurer, P1 Insurance Company, hereinafter referred to as P1 Insurance, jointly sign in 07 boiler insurance contracts and public liability insurance contracts as follows. 1. Boiler Insurance Contract Number P15/DNA/XCG/3201/0005 dated March 24, 2015 includes Certificate of Insurance Boiler Insurance Number P15/DNA/XCG/3201/0005 dated March 24, 2015. Notice of charge collection on March 24, 2015. Additional terms, rules of boiler insurance stipulate that Company N is insured by P1 Insurance. Two, Public Liability Insurance Contract Number P15/DNA/XCG/3303/0009, dated March 24, 2015 includes Certificate of Public Liability Insurance No. P15/DNA/XCG/3303/0009, dated March 24, 2015, Public Liability Insurance Contract Number P15/DNA/XCG/3303/0009, dated March 24, 2015, Notice of Charge Collection on March 24, 2015. Rules of Public Liability Insurance. The amended terms of public liability insurance stipulates that Company N is insured by P1 Insurance an amount of 21,000,000,000 VND for each loss and for the whole year, person limited. Not exceeding VND 20 million/person/case. Insurance coverage. P1 Insurance compensates for personal injury or material damage occurring during the insurance due to an incident within the geographical limit related to the business activities of Company N, location insured. Company H, address. Quarter 8, Ward L, City B, Dong Nai Province. Geographical scope. Vietnam. Beneficiaries of insurance benefits. Bank V Branch B, Beneficiary 1. Company N, Beneficiary 2. Insurance period is from April 1, 2015 to March 31, 2016, hereinafter referred to as contract number 0009. 3. Boiler insurance contract number P15/DNA/XCG/3201/0006 dated March 26, 2015 includes Certificate of Insurance Boiler Insurance Number P15/DNA/XCG/3201/0006 dated March 26, 2015. Notice of Charge Collection on March 26, 2015. Additional terms, rules of boiler insurance stipulate that Company N is insured by P1 Insurance. Regarding property damage. Biomass kiln number 03, common name boiler number 3, with an insurance amount of 13 billion VND, regarding liability to third parties. Limits of liability of 1 billion VND per accident throughout the insurance period, including about human. Plus compensate each person 20 million VND for each incident, plus compensate the total number of people 200 million VND per incident in the insurance period, about assets. 200 million VND per incident in the insurance period. Location insured. S-Paper Limited Company, as known as S-Paper Joint Stock Company, referred to as S-Paper Company, address M Industrial Park, T District, Baria, Vung Tau Province. Beneficiaries of insurance. Bank V Branch B. Duration of insurance participation is from April 1, 2015 to March 31, 2016. Hereinafter referred to as contract number 0006. For Public Liability Insurance Contract number P15/NS/XCG/3303/0010 dated March 26, 2015 includes Certificate of Public Liability Insurance No. P15/DNS/XCG/3303/0010, March 26, 2015. Public Liability Insurance Contract number P15/DNS/XCG/3303/0010 dated March 26, 2015. Notice of Charge Collection on March 26, 2015. Rules of Public Liability Insurance stipulate that Company N is insured by P1 Insurance an amount of 21 billion VND for each loss in the whole year, limit of people not exceeding VND 20 million/person/case. Insurance coverage. P1 Insurance compensates for body injury or property damage of third parties whom Company N is legally to pay occurring within the period of insurance due to incidents relating to the business activities of Company N, location insured. Paper S Company, address M Industrial Park, T District, Baria, Vung Tau Province. Geographical scope. Vietnam. Beneficiaries of insurance benefits. Bank V Branch B, Beneficiary 1. Company N, Beneficiary 2. Duration of insurance participation is from April 1, 2015 to March 31, 2016. Hereinafter referred to as contract number 0010. 5. Boiler insurance contract No. P15/DNA/XCG/3201/0007 dated September 30, 2015 includes Certificate of Insurance Boiler Insurance Number P15/DNA/XCG/3201/0007 dated September 30, 2015. Notice of Charge Collection on September 30, 2015. Additional terms, rules of boiler insurance stipulate that Company N is insured by P1 Insurance. Regarding property damage. Biomass dryer number 1, common name is boiler number 1, with an insurance amount of 9,300 million VND, regarding liability to third parties. Limits of liability of 1 billion VND per accident throughout the insurance period, including about human, plus compensate each person 20 million VND per each incident, plus compensate the total number of people 200 million VND per incident in the insurance period, about assets. 800 million VND per accident during the insurance period. Location insured. Paper S Company, address M Industrial Park, T District, Baria, Vung Tau Province. Beneficiaries of insurance. Bank V Branch B. Duration of insurance participation is from October 1, 2015 to October 1, 2016. Hereinafter referred to as contract number 0007, but 6. Boiler Insurance Contract No. P15/DNA/XCG/3201/0008 dated September 30, 2015 includes Certificate of Insurance Boiler Insurance Number P15/DNA/XCG/3201/0008 dated September 30, 2015. Notice of charge collection on September 30, 2015. Additional terms, rules of boiler insurance stipulate Company N is insured by P1 Insurance. Regarding property damage. Biomass kiln number 02, common name is boiler number 2, with an insurance amount of 5,400,000,000 VND, regarding liability to third parties party. Limits of liability of 1 billion VND per accident throughout the insurance period, including about human, plus compensate each person 20 million VND for each incident, plus compensate the total number of people 200 million VND per incident in the about assets. 800 million VND per accident during the insurance period. Location insured. Paper S Company, address M Industrial Park, T District, Baria, Vung Tau Province. Beneficiary of insurance. Bank V, Branch B. Duration of insurance participation is from October 1, 2015 to October 1, 2016. Hereinafter referred to as contract number 0008. 7. Public Liability Insurance Contract Number P15/NA/XCG/3303/0057 dated September 30, 2015. The content of the contract includes Certificate of Public Liability Insurance No. P15/DNA/XCG/3303/0057 dated September 30, 2015. Notice of collection of insurance premiums, September 30, 2015. Public Liability Insurance Contract No. P15/DNA/XCG/3303/0057 dated September 30, 2015. Additional terms for public liability insurance coverage. The Public Liability Insurance Rule, under which Company N is insured by P1 Insurance with an amount of VND 21,000,000,000 for each loss in the whole year, not exceeding VND 20 million/people/case. Scope of coverage. P1 Insurance compensates for damages to bodily injury or property of third parties to which Company N is legally obligated to pay occurring within the period of insurance due to incidents relating to business activities of Company N, insured location. At Paper Company S, address M Industrial Park, T District, Baria, Vung Tau Province. Geographical scope. Vietnam. Beneficiaries of insurance benefits. Bank V, Branch B, Beneficiary 1, Company N, Beneficiary 2, insurance period is from October 1, 2015 to October 1, 2016. Hereinafter referred to as contract number 0057. At 0030, November 13, 2015, at S Paper Company, there was boiler number 3 explosion. As the results, 1. Regarding physical damage to the number 3 boiler. The entire boiler system number 3 was destroyed. Property damage to third parties. Firefighting costs, property damage, construction costs, damage caused by shutdown of S Paper Company. 2. About human. 02 workers who directly operated boiler number 3, Mr. Nguyen Van C and Mr. Nguyen Tan L, died. 3. Expenses for on-site cleaning. Dismantling, cleaning, transporting and depositing assets on the scene after the explosion of boiler number 3, 4. Influencing and damaging a part of boiler number 2 of Company N. At 10:00 a.m., November 13, 2015, Insurance P and Company N made an on-site working record. The investigation Police Department of Baria Vung Tau Province solicited the expertise of the cause of the incident. On January 13, 2016, there was an inspection conclusion No. 3548/C54B of the Criminal Science Sub-Institute, C54B, Ministry of Public Security, presenting 03 documents of the Investigation Police Agency, Police of Baria Vung Tau Province on the same day, January 26, 2016. Notice number 02/TBPC44 about not prosecuting criminal cases. Conclusion verifying criminal information number 02/KLPC44 D3 notifying results of resolution of criminal notices number 02/TBPC44 official letter number 100/VKSP2 dated January 26, 2016 of the People's Procuracy of Bahria Vung Tau Province regarding the conclusions on verifying the denunciations and the cause of explosion of the number 3 boiler. The number 3 boiler is still in the inspection period, issued by Industrial Testing Center 2. Ministry of Industry and Trade. The next inspection date is December 17, 2016, so the boiler explosion on November 13, 2015 had no signs of crime. P1 Insurance appointed Inspection Joint Stock Company B, address 2.5P, Ward B, District P, Ho Chi Minh City to conduct inspection of loss on boiler explosion incident. The inspection was carried out in November 17, 18, 19, 20 and 28, 2015 reported in the on-site records, showing the damages including boiler number 3, boiler houses 1 and 2, mutual equipments of boiler number 1, number 2 and number 3, mechanical and electrical damage of boiler number 2, third-party assets of Paper S Company, actual on-site cleanup. Company N synthesized and submitted the data and requested the compensation from P Insurance Joint Stock Corporation and P1 Insurance Corporation, based on legal grounds. 1. Regarding material damage to the boiler number 3, Company N based on the boiler insurance contract No. P15/DNA/XCG/3201/0006 dated March 26, 2015, the explosion of boiler number 3 was within the scope of insurance responsibility of Insurance Company P, including boiler number 3 system V&D 13,886,965,686, boiler house number 3 V&D 1,298,476,400, equipment and supplies, increasing the ability to use burning fuels. V&D 2,519,308,592, expenses incurred for site cleanup. Company N based on clause 25 of the field cleanup terms, $100,000 limit of the additional terms of contract number 0006, the costs incurred for cleaning up the site due to the explosion of boiler number 3 was within the scope of insurance liability of Insurance P, plus dismantling, craning number 3 boiler. V&D 140 million, plus freight, big trailers. V&D 20 million, plus cleanup and shipping. V&D 200 million, plus rent for storage of boiler number 3. V&D 120 million, in total. V&D 18,184,750,678. 2. Loss of lives. N Company based on the contract number 0009, 0010, 0057, the explosion of the boiler number 3, causing the loss of 2 persons occurred in the geographical area Vietnam, under the scope of public insurance liability of Insurance Company P with actual damage, Mr. Nguyen Van C. V&D 300 million, Mr. Nguyen Ton L. V&D 333 million, in total. V&D 633 million. 3. Regarding property damage to the third party. Company N based on the contract number 0009, 0010, 0057, the explosion of boiler number 3, the property damages of a third-party S Paper Joint Stock Company, occurring within geographical range Vietnam, under the scope of public insurance liability of P Insurance Company with total actual damage, property damage, construction costs. V&D 90,804,880, firefighter costs. V&D 24,943,000, damage caused by production interruption. V&D 332,010,000, compensation for S Paper Joint Stock Company for the costs of the difference of gas price in November 2015, due to the explosion of boiler number 3. V&D 1,063,032,472, in total. V&D 1,510,790,352. 4. Damages to the boiler number 2. Company N, based on the contract number 0008, claimed that damages to the boiler number 2 were covered P Insurance Company, damage to mechanical part. VND 200 million, damage to electricity. VND 300 million, in total. 500 million VND. From P Insurance Company's side, 1. Disagreeing to pay material liability for boiler number 3 and public insurance liability for people and third-party assets to Company N, and due to denying the validity of contract number 0006 and contract number 0010, reflected in official letter number 130/PDNSEV, dated November 24, 2015 of P1 Insurance, denying the validity of contract number 0005 and contract number 0009 through official letter number 136/PDNSEV dated December 1, 2015. On November 26, 2015, Company N sent official letter No. January 2015/PHTTNTNPHCODNN to P Insurance for not accepting the insurance liability disclaimer of Insurance P and asking for the compensation of all the damages. Insurance P continued to refuse to compensate, shown in official letter number 135/PDNSEV, dated January 12, 2015, with the explanation: Company N must have paid the insurance premium before May 1, 2015, but until May 7, 2015, P1 Insurance received the insurance premium. The payment terms in these contracts expired on May 1, 2015, the date of loss and damages was on November 13, 2015, so the loss and damages were not covered by the insurance responsibility of Insurance P. Disagreeing with the denial of insurance liability of Insurance P, on December 2, 2015, Company N sent a written complaint to Insurance P. It was ungrounded that Insurance P refused to compensate on the effective date of the contract. According to Article 405, civil law stipulates, contracts that are legally entered into shall take effect from the time they are entered into, unless otherwise agreed upon or provided for by law. Time enter on civil contracts at the time when the offeror receives the reply of acceptance to enter into the contract, Clause 4 Article 404, or the time at which the last party signs the contract, Clause 4 Article 404. In fact, Insurance P issued the insurance certificates for the contract number 0005 dated March 24, 2015. Contract number 0009 dated March 24, 2015. Contract number 0006 dated March 26, 2015. Contract number 0010, dated March 26, 2015, and issue the value-added invoices for Company N. Insurance P was received the insurance premium on May 7, 2015, with total insurance premium of all contracts is 91,179,000 VN. Two parties had no agreed upon by the parties about the time the contract goes into effect. Insurance P has responsibilities for compensating damages to Company N according to Clause 1, Clause 3 Article 15 about the time when the insurance liability arises of law amending and supplementing a number of article of the insurance business law. Terminating the effect of contract. According to Clause 2 Article 23 the insurance business law, insurance contract ends when the insurance buyer fails to fully pay the premium or fails to pay the premium within the time limit agreed upon in the insurance, according to the agreement of Insurance P and Company N in term of payment of boiler insurance contracts. Number 0005 and number 0006. In case the assured fails to fully pay the premium or fails to pay the premium comes after payment article of the insurance contract. The payment article of the boiler insurance contract wrote insurance premium will be paid for the assured by transfer on one time. Company N paid insurance premium by transfer only one time with total money is 91,179,000 VN, Insurance P received it, or any payment agreements that two parties agree in writing. The validity of the insurance contract will automatically terminate on the next day. The insured person must pay the fee as agreed by the insurance contract or the attached amendments/annexes, if any. Under Article 23, the commitment to pay insurance premiums is the additional provision that Company N only applies when and only if it is more beneficial for Company N than the payment terms agreed in the insurance contract, but without prejudice to the rights of the parties under this application. According to the explanation cited to deny the validity of the insurance contract, does not liable for compensation to Insurance P is not beneficial to Company N, so the additional provision on payment is invalid. On the other hand, the additional terms are part of contract number 15/DNN/XCG/3201/0005, it is not part of contract number 0005, P15/DNN/XCG/3201/0005 of contract number 15/DNN/XCG/3201/0006. It is not contract number 0006, no. P15/DNA/XCG/3201/0006. Under Public Liability Insurance Contracts. Contract number 0009, number 0010, Insurance P refers to Article 5 as a provision on the commitment to pay premiums, 15 days, which not only deny the validity of the contract but also do not accept the liability for insured events. Compensation for Company N is unfounded, because it is not related to contract number 0009, number 0010, and disadvantage for Company N when applying the additional terms, if any, amendments to supplement of public liability insurance are part of contract no. 15/DNA/XCG/3303/0009, not part of contract number 0009, no. P15/DNA/XCG/3303/0009 is a part of contract number 15/DNA/XCG/3303/0010, not a part of contract number 0010. P15/DNA/XCG/3303/0010, terms of commitment to pay insurance premiums, 15 days. Are additional terms only applied when it is more beneficial than other terms agreed in the contract number 0009, number 0010, but these contracts do not stipulate the contract terminates due to late payment of insurance premium. 2. Regarding damage of boiler number 2. Insurance P intentionally evades performing the liability to pay damages under contract number 0008 as committed at Part 3 of Official Letter number 130/PDNICV dated November 24, 2015. Because of that, the authorized representative of Company N keeps all requests to sue, but on September 29, 2016 and at the first instance trial, the plaintiff's authorized representative withdraw a partial request as follows, recognizing the validity of the public liability insurance contract no. P15/NA/XCG/3303/0009 dated March 24, 2015 between insurance party P1 and the insured company N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating Company N for all damage when an insured event occurs. Recognizing the validity of the public liability insurance contract no. P15/NA/XCG/3303/0009, dated March 24, 2015 between P1 Insurer and Insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating Company N for all damages when an insured event occurs. Compensation to Company N for public liability insurance is 633 million VN under the Public Liability Insurance Contract no. P15/NA/XCG/3303/0009 dated March 24, 2015, Public Liability Insurance Contract no. P15/NA/XCG/3303/0010 dated March 26, 2015, Public Liability Insurance Contract number P15/NA/XCG/3303/0057 dated September 30, 2015. Excluding 150% overdue interest in the claim for damage caused by insurance company P delay the performance of insurance compensation obligations, partially withdraw the claim for compensation for Company N of the entire explosion damage of biomass fluidized bed boiler number 3 under the boiler insurance contract no. P15/DNA/XCG/3201/0006 dated March 26, 2015. VND 18,184,750,678, only VND 13 billion and VND 200 million are required to clean the scene. The authorized representative of Company N still maintains the remaining lawsuit requests and requests the court to resolve and force Insurance Joint Stock Company P to 1. Recognizing the validity of the boiler insurance contract number P15/NA/XCG/3201/0006, dated March 26, 2015, between the insurer P1 and the insured N, Insurance Joint Stock Company P is responsible for compensating Company N for all losses. 2. Recognizing the validity of the public liability insurance contract no. P15/NA/XCG/3303/0010 dated March 26, 2015, between the insurer P1 and the insured N, Insurance Corporation P, Insurance Corporation P, is responsible for compensating Company N for all losses. 3. Compensation for Company N for the entire loss of explosion biomass. Number 3. Fluidized bed boiler under the boiler insurance contract of P15/DNA/XCG/3201/0006 dated March 26, 2015. 13,000,000,000 VND. 4. Clean up the scene. 200 million VND. 5. Compensation to Company N for public liability insurance for assets of the third party due to the explosion of boiler No. 3 with the amount of 1,510,790,352 VND according to the public liability insurance contract No. P15/NS/XCG/3303/0010 dated March 26, 2015, public liability insurance contract No. P15/DNA/XCG/3303/0057 dated September 30, 2015. 6. Compensation for Company N for the entire loss of the biomass. Number 2. Fluidized bed boiler is VND 500 million under the boiler insurance contract of P15/DNA/XCG/3201/0008 dated September 30, 2015. 7. Compensation due to delayed performance of the insurance indemnity obligation after 15 days from November 19, 2015 until the date receive reasonably valid claim, inscribed by P1 Insurance in official letter number 130/PDNSEV, dated January 24, 2015. It means from April 12, 2015 to the date of first instance trial on November 10, 2016 follow the basic interest rate issued by the State Bank. VND 15,210,790,352 x 10 days 7 days x 9%/year equals VND 1,167,428,159 in total. 3 plus 4 plus 5 plus 6 plus 7. VND 16,378,218,511. The additional parts for the court to consider and resolve. 1. According to Public Liability Insurance Contracts number 0009, 0010, and 0057, the jurisdiction to resolve disputes is settled by the competent People's Court as provided in Article 2.3 of the contracts. 2. Regarding boiler insurance contracts, Company N is based on Article 17 of the Commercial Arbitration Law No. 54/2010/QH12, June 17, 2010, Clause 5, Article 4 of Resolution No. 01/2014/NQHDTP dated March 20, 2014 of the Council of Judges of the Supreme People's Court. Because the boiler insurance rules and boiler insurance contracts are stamped between the insurance provider P1 and the insured Company N and prepared by P1 Insurance Service Provider with a chosen arbitration agreement, Company N is entitled to choose the arbitration or the court to dispute resolution. Company North chooses the court to resolve the dispute. The plaintiff's authorized representative agrees with the valuation certificate number 2003/TDGCT of August 22, 2016 of Valuation Joint Stock Company D. and has no comments. The plaintiff's authorized representative listened to the court explaining to Mr. Chutan T that Mr. T did not agree with the valuation certificate. Mr. T has the right to ask the court to re-evaluate those properties, but Mr. T has no idea and requests the court to settle in accordance with the law. Also do not ask for anything more. The authorized representative of the defendant presents A. The ideas about the contents of the petition include from the first content to the seventh content of Company N according to the petition dated May 17, 2016, as follows. I. Boiler Insurance Certificate No. P15/DNN/XCG/3201/0006 has been agreed and signed by P1 Insurance and Company N on March 26, 2015. Comply with the law. Insurance policy set includes Insurance Certificate, Insurance Fee Notice, Insurance Rules, additional terms stamped by Insurance P. However, during contract performance, Company N did not fulfill all commitments in the contract, which led the contract expired before the time of the loss. In particular, according to payment article at the Insurance Certificate and Supplementary Clause 26, the payment term stipulated as follow. 1. According to the time limit inscribed in the Insurance Certificate. Time for payment. Within 15 days from March 26, 2015, terms of payment shown in the contract. The insurance premium will be paid to the insured in cash, check, or bank transfer in lump sum. As follows: in case the insured fails to fully pay the premium or fails to pay the premium within the time limit agreed upon in the insurance contract, except otherwise agreed upon by the parties, the effective insurance contract will automatically end on the next day. The insured must pay fees as agreed upon in the insurance contract with the attached amendments/annexes, if any. Therefore, under this time for payment, Company N must pay the insurance premium to Insurance P before April 10, 2015. This is also stated by Insurance P in the collection notice sent to Company N, March 26, 2015. 2. Under Additional Terms 23. Terms of commitment to pay insurance premiums, 30 days. 1. The parties agree and acknowledge that, regardless of any contrary conditions in this policy, and based on the second condition below, but without prejudice to the rights of parties under this application, the prerequisite for binding Insurance P's liability under the insurance policy, reinstatement, supplementary terms provisional insurance certificate, the insured had made full payment of any calculated premium and Insurance P. The broker or insurance agent who issued or arranged this insurance policy must receive such premium within the time for payment as follows. If the insurance duration is 30 days or more, the payment must be paid within 30 days from 1. The effective date of the insurance policy, reinstatement, or provisional insurance certificate. 2. The effective date specified in each additional clause, if any, issued according to the insurance policy, reinstatement, provisional insurance certificate if the effective date of insurance listed the release date of additional terms. 3. The date release additional clause, if any, issued under the insurance policy, reinstatement or provisional certificate of insurance if the effective date specified in this supplementary clause comes into before releasing date. Or, B. If the insurance duration is less than 60 days, within the insurance duration stated in the application's reinstatement, supplementary terms, or provisional insurance certificate. 2. In case the insurance premium mentioned above has not been paid in full for Insurance B, broker, agent as declared under the nature and time mentioned above, payment guarantee duration insurance premium, the validity of insurance policy, reinstatement, supplementary terms, or provisional certificate will be terminated from the expiry date of the guarantee duration. Insurance P will be exempt from all liabilities from then on, and in this case, Insurance P will be entitled to a premium calculated on the effective date of the policy, but not smaller than $20. Therefore, under this fee payment term, Company N must pay the insurance premium to P before May 1, 2015. Based on the above payment agreements, Company N must pay the premium before the latest date is May 1, 2015 in accordance with Boiler Insurance Certificate P15DN/XCG/3201/0006 for Insurance P, but until May 7, 2015, P receives the premium from Company N. Delayed 7 days follow the provisions of Supplementary Clause 23, 26 days follow the provision of payment in Insurance Certificate. Therefore, based on the payment terms on the Insurance Certificate and Supplementary Clause 23, pursuant to Point A, Clause 2, Article 18 and Clause 2, Article 23 of the Law on Insurance Business, Clause 4, Article 2 of Circular No. 194/2014/TTBTC, dated December 17, 2014, come into effect on February 1, 2015 of the Ministry of Finance, Company P had no obligation to pay loss caused by explosion of biomass No. 3 fluidized bed boiler with a capacity of 30 tons/H according to the boiler. Insurance Certificate Number P15/DNN/XCG3201/0006 occurred on November 13, 2015 of Company N at S Paper Company Limited, Industrial Park M, T District, Baria, Vung Tau Province due to the insurance contract No. P15/DNA/XCG/3201/0006 was no longer valid on May 1, 2015, before insured event occurs on November 13, 2015. 2. Public Liability Insurance Contract No. P15/DNA/XCG/3303/0010 has been agreed and signed by P1 Insurance and Company N on March 26, 2015. The Ministry of Contract includes Insurance Contract, Insurance Rules, additional terms are sealed. However, during the contract performance, Company N did not fulfill all the commitments in the contract, which led the contract to expire before the damage occurred, specifically as follows, according to the insurance certificate and additional terms. The payment term is prescribed. 1. Pursuant to the time limit inscribed in the insurance certificate. Payment duration. Within 15 days from the date the deed issued on, thus, under the time for payment, Company N must pay the insurance premium to Insurance B before April 10, 2015. This is also stated by Insurance B in the collection notice dated March 26, 2015 sent to Company N. 2. Pursuant to Supplementary Clause 23. The payment commitment term. Any contradiction stated herein. Without prejudice to Article 2. The parties declare and agree that the precondition for liability under this insurance policy, reinstatement, supplementary amendment, or provisional insurance certificate must be paid and fully received by the insurance company, broker, or registered business agent. If the insurance duration is 30 days or more, within 30 days from 1. The date that the insurance receives under the insurance policy, reinstatement, or provisional insurance certificate, or 2. The insurance effective date specified in each amendment, if any, issued under the insurance policy, reinstatement, provisional insurance certificate when the effective date of insurance show on the amendment is on or after the date released those amendments, or Fadhan Sua Doi Bosung Du. 3. The release date for supplementing amendment, if any, released in accordance with insurance policy, reinstatement, or provisional insurance certificate when the insurance effective date of insurance shown on the amendment is before the release date. B. If insurance duration is shorter than 7 days, within the scope of insurance duration stated in the insurance policy, reinstatement, or provisional insurance certificate, when any aforementioned premiums is not paid in full to the insurance company, broker, or agent registered as above description, follow the mode and duration hereby, the payment commitment term. The insured under the insurance policy, reinstatement, or provisional insurance certificate will be automatically terminated from the effective date of the contract, and the insurance company will be released all liabilities from that date. Therefore, according to the aforementioned payment term, Company N must pay the insurance premium to Insurance B before May 1, 2015. Based on the above payment agreements, before the latest date is May 1, 2015, Company N must pay the premium under the Public Liability Insurance Contract Number P15/DNA/XCG/3303/0010 for Insurance B. However, until May 7, 2015, Insurance B received premium from Company N, delayed 7 days under the provisions of Supplementary Clause 23, 26 days in accordance with the provision of payment in insurance certificate, that therefore, based on the payment terms in the insurance contract, pursuant to Point A, Clause 2, Article 18 and Clause 2, Article 23 of the Law on Insurance Business, Clause 4, Article 2 of Circular No. 194/2014/TTBTC of December 17, 2014, which take effect on February 1, 2015 of Ministry of Finance, Insurance Company P1 have no responsibility for compensation to Company N, to the third party related to losses due to explosion of the biomass No. 3 fluidized bed boiler, capacity of 30 tons/h. Under the Public Liability Insurance Contract No. P15/DNA/XCG/3303/0010, occurred on November 13, 2015 at Company Limited S. Industrial Park M. T District, Baria, Vung Tau Province, because this insurance policy has terminated take effect on May 1, 2015, before the loss occurred on November 13, 2015. 3. Boiler Insurance Certificate Number P15/DNA/XCG/3201/0008 has been agreed and signed by Insurance P1 and Company N on September 30, 2015. The contract includes the insurance certificates, insurance rules, additional terms. All of this document are sealed by Insurance P. Based on these documents, Insurance P would like to inform the following: the contract No. P15/DNA/XCG/3201/0008, the insurance for biomass boiler number 2 has been fully fulfilled by Company N under the contract. Therefore, Insurance P will consider for compensation abide by rules. This has been updated by Insurance P in Official Letter 130/PDNACV dated November 24, 2015. Currently, the two agree to make an offer for assessment. When it has results come true, Insurance P will make compensation as prescribed. For the loss of boiler number 2, Insurance P, as the plaintiff stated, Insurance Company P is cooperating with Company N and Assessment Joint Stock Company B to determine the damage value. Then make compensation as prescribed. Currently, the case is, so we request the court not accept this content. 4. The Public Liability Insurance Contract, No. P15/NA/XCG/3303/0009 has been agreed and signed by Insurance Company P1 and Company N on March 24, 2015. Comply with the law. The contract includes insurance certificate, fee notice, insurance rules, additional terms stamped by Insurance P. According to this insurance contract, the insured event located Company H that have no relation with the damage occurred at S Paper Company, therefore, requesting the court not accept this content. V. For Company N's claims about people under the public liability insurance contracts, No. P15/DNA/XCG/3303/0009 dated March 24, 2015, the public liability insurance contract, No. P15/DNA/XCG/3303/0010 dated March 26, 2015, and the public liability insurance contract, No. P15/DNA/XCG/3303/0057 dated 39/2015, requesting the court to reject because those public liability insurance contracts do not cover employees for the insured. 6. For losses related to liability of the third party of application P15/DNA/XCG/3303/0057 Insurance Company P1 is cooperating with Company N and Assessment Joint Stock Company B to determine the damage value. Based on that, the insurance company P1 compensates as prescribed. Currently, the case is settling, so we ask the court not accept this content. B. The idea for the ninth content of Company N's petition, according to the petition dated May 17, 2016, as follows: the calculation of interest rates due to late payment of compensation for all lawsuit requests is groundless for the following reasons. 1. The boiler insurance certificate, No. P15/DNA/XCG/3201/0006 and the public liability insurance contract, No. P15/DNA/XCG/3303/0010 was no longer valid on May 1, 2015, before the loss occurred on November 13, 2015, as stated in Section 1 and 2, Part A. This means calculating interest rates due to late payment is unfounded. 2. The boiler insurance certificate number P15/DNA/XCG/3201/0008, the public liability insurance contract number P15/DNA/XCG/3303/0057. On November 24, 2015, Insurance Company P1 issued a dispatch number 130/PDNICV announcing that your company has fulfilled its obligation to pay fees in accordance with regulations. Insurance P will coordinate/guide your company the next steps to consider the insurance scope and liability of the loss according to this insurance certificate. After the loss occurs, Insurance P has hired Assessment Company B to coordinate/guide Company N to collect documents to determine the reason and level of the loss to have a foundation, then consider the compensation for losses under this insurance contract. Hiring an independent Assessment Company B has been approved by Insurance P Company N. But until now, Company N has not provided sufficient documents proving the loss according to the written request and guided by many meetings of Assessment Joint Stock Company B. Insurance P is responsible for compensation within 15 days from the date receive a complete and valid file under the law on insurance business, insurance rules, and valid insurance contracts. In this case, Company N has not provided sufficient documents as prescribed, therefore, P has not been made compensation for biomass number 2 boiler damage, so it cannot be assumed that Insurance P is late in performing its obligations under such as a lawsuit filed by Company N. 3. Regarding the time limit for calculating a complaint to delay the performance of compensation obligations, the loss occurred on November 13, 2015, while Company N complained about the late performance of compensation obligations since January 19, 2015. The time Company N mentioned the interest rate calculation is not related to the time of loss, nor is it related to Official Letter 130/PHCODNICV dated November 24, 2015 that P1 Insurance sends to Company N. 4. Provisions on compensation because it delayed payment obligations. Under the insurance business law and insurance rules, the insurer is responsible for compensation for the assured within 15 days from the date of receiving a complete and valid dossier as prescribed. Insurance Company P has fulfilled its responsibilities in accordance with the terms and conditions agreed by the parties in insurance contracts and certificates No. P15/DNA/XCG/3201/0006, P15/DNA/XCG/3303/0010 and P15/DNA/XCG/3303/0009. The refusal of compensation for these contracts/certificates is in comply with the commitments in the contract and the provisions of the Law on Insurance Business, Circular No. 194/2014 TT-BTC dated December 17, 2014, come into effect on February 1, 2015 of the Ministry of Finance. Because of those reasons, it requests the court no accept all of the plaintiff's claim. Regarding Valuation Certificate No. 2003/TDGCT dated August 22, 2016 of Assessment Joint Stock Company D, Insurance B has an opinion not agree with that valuation certificate because it is not appropriate and in accordance with the laws. The court has explained that the defendant has the right to request a re-evaluation. The defendant has sent written opinion to the court that the use of valuation certificates as a foundation for insurance compensation does not accordance with the provisions of the Law on Insurance Compensation. Then it requests the court to resolve the case in accordance with the law. The persons with related interests and duties Insurance Company P1 represented by Mr. Chutan T said, agree with the defendant's opinion in the self-declaration dated June 27, 2016, the mediations and no other comments. The opinions of the Insurance Corporation P, Insurance P, to the court are also his opinions as the legal representative of the person with related rights and obligations Insurance Company P1. The persons with related interests and duties Joint Stock Commercial Bank V is presented the authorized representative, Ms. Ha Titan H. present, on May 8, 2013, Company N, hereinafter abbreviated to the customer, mortgaged assets to Joint Stock Commercial Bank V Branch B, hereinafter referred to Bank, is a boiler installation system located at Joint Stock Company H, under the property mortgage contract number 069/13/VCB.BH on May 8, 2013. The boiler system installed at Joint Stock Company H has been bought insurance by the customer as follows. Plus the boiler insurance contract, No. P15/NA/XCG/3201/0005 dated March 24, 2015 with the first beneficiary is Commercial Joint Stock Bank V Branch B. The insured amount is 6,500,000,000 VND, insurance duration from March 1, 2015 to March 31, 2016. Plus public liability insurance contract number P15/NA/XCG/3303/0009 dated March 24, 2015 with the first beneficiary of Vietnam Commercial Joint Stock Bank V Branch B. The amount of VND 21 billion, insurance duration is from April 1, 2015 to March 31, 2016. On October 1, 2014, Company N mortgaged an asset to the bank, which is a boiler system installed at One Member Limited Liability S Paper Company, Boiler 2, under property mortgage contract number 207/14/VCB.BH, dated October 1, 2014. The boiler system number 2 located at Company S has been bought insurance by customers as follows. Plus the boiler insurance contract number P15/NA/XCG/3201/0008 dated September 30, 2015 with the first beneficiary is Joint Stock Commercial Bank V Branch B. The amount of is 5,400 million VND, insurance duration from October 1, 2015 to October 1, 2016. Plus public liability insurance contract number P15/NA/XCG/3303/0057 dated September 30, 2015 with the first beneficiary is Joint Stock Commercial Bank V Branch B. The amount of is 21 billion VND, insurance duration from October 1, 2015 to October 1, 2016. Those assets are used to secure Company N's loans at Joint Stock Commercial Bank V Branch B under the credit contracts with the following details. According to the report of the boiler explosion incident of Company N to Joint Stock Commercial Bank V Branch B on November 16, 2015, at approximately 00:30 a.m. on November 13, 2015, at Company S address. Industrial Zone M, District T, Ba Ria Vung Tau Province occurred the number 3 boiler explosion of customers. The incident has caused damage all assets, which are mortgaged at the bank under mortgage contract number 055/15/VCB.BH dated June 2, 2015. The damage value is estimated about 13 VND. On November 16, 2015, the bank went to the incident scene and worked with Company N, details under the working paper dated November 16, 2015. The bank requires the customer to provide details of the mortgaged property status and actively works with insurance company P to compensate for the damage caused by the incident. According to the Notice of Acceptance of the Case Number 72/2016/TBKDTM dated June 2, 2016 of the People's Court of Bien Hoa City on the dispute of insurance contract, Company North requests the court to resolve the following specific issues. 1. Recognizing the validity of the boiler insurance contract P15/DNA/XCG/3201/0006 date March 26, 2015 between the insurance P1 and the insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses for Company N mentioned below. 2. Recognizing the validity of the boiler insurance contract, No. P15/NA/XCG/3303/0010 dated March 26, 2015 between Insurance P1 and Insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses for Company N mentioned below. 3. Recognizing the validity of the boiler insurance contract No P15/DNA/XCG/3201/0005 dated March 24, 2015 between Insurer P1 and Insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all damage for Company N when an insured event occurs. 4. Recognizing the validity of the boiler insurance contract P15/DNA/XCG/3303/0009 dated March 24, 2015 between Insurer P1 and Insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating Company N for all of the damage mentioned below and other damages when an insured event occurs. 5. Compensating for Company N all losses of the biomass fluidized bed boiler number 3 explosion under the boiler insurance contract No. P15/NA/XCG/3201/0006 dated March 26, 2015 with the amount of 18,184,750,678 VND. 6. Compensating for Company N 633 million VND under Public Liability Insurance Contract No. P15/NA/XCG/3303/0009 dated March 24, 2015, the Public Liability Insurance Contract No. P15/NA/XCG/3303/0010 dated March 26, 2015, the Public Liability Insurance Contract No. P15/NA/XCG/3303/0057 dated September 30, 2015. 7. Compensating to Company N the public liability insurance for the assets of the third party caused by the incident of boiler number 3 with the amount of 1,510,790,352 VND according to the Public Liability Insurance Contract No. P15/NA/XCG/3303/0009 dated March 24, 2015. The Public Liability Insurance Contract Number P15/ND/XCG/3303/0010 dated March 26, 2015, the Public Liability Insurance Contract No. P15/NA/XCG/3303/0057 dated September 30, 2015. 8. Compensating for Company N all losses of the biomass number 2 fluidized bed boiler is 500 million VND under the boiler insurance contract of P15/DNA/XCG/3201/0008 dated September 30, 2015. 9. Compensating for damage due to delay in the performance of contractual obligations after 15 days from January 19, 2015, recorded by Insurance P1 in Official Letter No. 130/PDNSEV dated November 24, 2015, until the date of first instance trial of a civil case based on average overdue interest rate. 20,828,541,030 VNDX 15 months, temporarily calculated from February 4, 2015 to May 4, 2016, x 9%/year x 150% equals 3,514,816,298 VND, in total, 5, plus 6, plus 7, plus 8, plus 9. 24,343,357,328 VND. In the contents of Company N's the lawsuit petition to Insurance Corporation P, Insurance Joint Stock Company P, as well as at the trial, the Joint Stock Commercial Bank V requests the court to judge fairly. For the assessment certificate number 2003/TDGCT dated August 22, 2016 of the Joint Stock Valuation Company D, the bank has no idea and requests the court to resolve in accordance with the law. At the first instance business judgment number 50/2016/KDTMST dated October 11, 2016, the People's Court of Bien Hoa City, Dong Nai Province decided, accept the petition of Company N, Forced Insurance Corporation P, Insurance Joint Stock Company P. 1. Recognizing the validity of the boiler insurance contract, no. P15/NA/XCG/3201/0006 dated March 26, 2015 between Insurer P1 and Insured N and Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating Company N for all losses. 2. Recognizing the validity of the public liability insurance contract, no. P15/NA/XCG/3303/0010 dated March 26, 2015 between Insurer P1 and Insured N, the Joint Stock Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating Company N for all losses. 3. Compensating for Company N all damages of the number 3 biomass fluidized bed boiler under the boiler insurance policy of P15/DNA/XCG/3201/0006, dated March 26, 2015. VND 13,000,000,000 VND 4. Clean up the scene. 200 million VND. 5. Compensating for limited liability company and the public liability insurance for the third party's assets due to the explosion of boiler number 3 with the amount of 1,510,790,352 VND, under the public liability insurance contract, no. P15/NA/XCG/3303/0010 dated March 26, 2015, Public Liability Insurance Contract Number PL5/NA/XCG/3303/0057 dated September 30, 2015. 6. Compensating for Company and all losses of the number 2 biomass fluidized boiler. 500 million VND, under the boiler insurance contract of P15/DNA/XCG/3201/0008 dated 30/09/2015. 7. Compensating for damage due to delayed performance of the insurance indemnity obligation after 15 days from November 19, 2015, receiving in full and valid compensation, recorded by Insurance P1 in official letter number 130/PDNACV dated January 24, 2015. December 4, 2015 until the date of first instance trial on October 11, 2016, based on the basic interest rate issued by the State Bank. VND 15,210,790,352 x 10 7 days x 9%/year equals 1,167,428,159 VND in total. 3 plus 4 plus 5 plus 6 plus 7. VND 16,378,218,511. Suspension a part of a lawsuit petition by Company N, including, recognize the validity of the public liability insurance contract, no. P15/NA/XCG/3303/0009 dated March 24, 2015 between Insurer P1 and Insured N, the Joint Stock Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses for Company N when an insured event occurs, recognize the validity of the public liability insurance contract, no. P1/NA/XCG/3303/0009 dated March 24, 2015 between Insurer P1 and Insured N, the Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses for Company N when an insured event occurs. Compensating for Company N the public liability insurance is 633 million VND, under the public liability insurance contract, no. P15/NA/XCG/3303/0009 dated March 24, 2015, the public liability insurance contract, no. P15/NA/XCG/3303/0010 dated March 26, 2015, the public liability insurance contract, no. P15/DN1/XCG/3303/0057 dated September 30, 2015, excluding 150% of the overdue penalty interest at the claim for damage due to delay compensation obligations insurance company P. Part of the compensated claim for company and all losses of the biomass fluidized bed boiler number 3 explosion under the boiler insurance contract No. P15/DNA/XCG/3201/0006 dated March 26, 2015 is 4,984,750,678 VND. Insurance Corporation P, Insurance Joint Stock Company P, must reimburse Company N the total assessment cost. VND 134 million. Besides, the Court of First Instance also decided on the responsibility for delaying the execution of the court fees and the right to appeal of the involved parties. On October 20, 2016, the defendant Insurance Joint Stock Corporation P has an appeal filed to the entire first instance business judgment. In the appellate business judgment No. January 2017/KDTMPT dated March 6, 2017, the People's Court of Dong Nai Province decided, rejecting all appeal requests of Insurance Corporation P, Insurance Joint Stock Company P, upholding the first instance judgment, except file a lawsuit of Company N, forced Insurance Corporation P, Insurance Joint Stock Company P. 1. Recognizing the validity of the boiler insurance contract No. P15/DNA/XCG/3201/0006 on March 26, 2015, between Insurer P1 and Insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses to Company N, recognizing the validity of public liability insurance contract No. P15/NA/XCG/3303/0010 dated March 26, 2015 between Insurer P1 and Insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses to Company N. 3. Compensating for Company N the entire loss of biomass number 3 fluidized bed boiler explosion under the boiler insurance contract of P15/DNA/XCG/3201/0006 dated March 26, 2015. VND 13,000,000,000 copper. 4. Clean up the scene/Don DPEN Truong. 200 million VND. 5. Compensating to Company N the public liability insurance for the third-party assets due to the explosion of boiler number 3 with the amount of VND 1,510,790,352, according to the public liability insurance contract No. P-15/NA/XCG/3303/0010 dated March 26, 2015, the public liability insurance contract No. P15/NA/XCG/3303/0057 dated September 30, 2015. 6. Compensating for Company and all losses of the number 2 biomass fluidized boiler. 500 million VND under the boiler insurance contract No. P15/DNA/XCG/3201/0008 dated 30/09, 2015. 7. Compensating for damage due to delayed performance of the insurance indemnity obligation after 15 days from November 19, 2015, the day receives reasonable valid claim, as insured P1 inscribed in official letter number 130/PDNACV dated January 24, 2015, December 4, 2015 until the date of first instance trial on October 11, 2016, based on the basic interest rate specified by the State Bank. VND 15,210,790,352 x 10 7 days x 9%/year equals 1,167,428,159 VND, in total, 3, plus 4, plus 5, plus 6, plus 7. Insurance Corporation P, Insurance Joint Stock Company P, is responsible to pay the compensation to Company N. 16,378,218,511 VND. Terminating a part of Company N's the request, including recognizing the validity of the public liability insurance contract No. P15/NA/XCG/3303/0009 dated March 24, 2015 between Insurer P1 and Insured N, Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses to Company N when the insured event occurs, recognizing the validity of the public liability insurance contract No. P15/NA/XCG/3303/0009 dated March 24, 2015 between insurer P1 and insured N. The Insurance Corporation P, Insurance Joint Stock Company P, is responsible for compensating all losses to the company when the insured event occurs. Compensating to Company N for the public liability insurance is 633 million VND, according to the public liability insurance contract No. PL5/NA/XCG/3303/0009, dated March 24, 2015. The public liability insurance contract number PL5/NA/XCG/3303/0010, dated March 26, 2015. The public liability insurance contract No. P15/NA/XCG/3303/0057, dated September 30, 2015, excluding 150% of the overdue penalty interest on damage claims due to insurance company P delayed performing of the insurance compensation obligation. Part of the claim for compensation the entire loss of biomass fluidized bed boiler number 3 explosion to Company N under the boiler insurance contract No. P15/DNA/XCG/3201/0006, dated March 26, 2015. 4,984,750,678 VND. Regarding the preceding expenses, Insurance Corporation P, Insurance Joint Stock Company P, will be paid the assessment cost of 134 million VND, so Insurance Corporation P, Insurance Joint Stock Company P, must be responsible to reimburse Company N the amount of 134 million VND from the date the plaintiff has a written request for judgment execution. If the defendant fails to pay the above amount and the assessment cost, the defendant must pay the late payment interest based on basic interest rate specified by the state bank. Correspond with the amount of late payment at the payment time. In addition, the appeal court decided on the court fee. After the appellate trial, the Insurance Corporation P has made a written request the appellate judgment mentioned above to cassation procedures. In decision number 45/QDKNGD-TVC3KDTM dated February 8, 2018, the Chief Procurator of the Superior People's Procuracy in Ho Chi Minh City appeals the judgment, requesting the Judicial Committee in Ho Chi Minh City adjudicating cassation and canceling the first instance business judgment number 50/2016/KDTMST dated October 11, 2016 of the People's Court of Bien Hoa City, Dong Nai Province, handing over the case file to the People's Court of Bien Hoa City, Dong Nai Province, to conduct a first instance trial according with the law. At the trial today, representatives of the Senior People's Procuracy in Ho Chi Minh City request the Judicial Committee in Ho Chi Minh City to accept the appeal of the Chief Procurator of the Superior People's Procuracy in Ho Chi Minh City. Part 4. Assessment of the Court. 1. According to the documents and evidence presented in the file, it shows 2. Company N supplies, installs and operates 03 boilers in Industrial Zone M, District T, Bà Rịa Vũng Tàu Province for S Paper Joint Stock Company, S Paper Company. At the same time, Company N and Insurance Company P1, Insurance Company P1, signed 05 boiler insurance contracts and the public liability insurance, specifically the boiler insurance contract number P15/DNA/XCG/3201/0006 dated March 26, 2015, contract number 06, the public liability insurance contract number P15/DNA/XCG/3303/0010 dated March 26, 2015, contract number 10, the boiler insurance contract No. P15/DNA/XCG/3201/0007 dated September 30, 2015, contract number 07, the boiler insurance contract No. P15/DNA/XCG/3201/0008 dated September 30, 2015, contract number 08, the public liability insurance contract number P15/NA/XCG/3303/0057 dated September 30, 2015, contract number 57. 3. About 0 hours 30 minutes on November 13, 2015, at the paper company occurs the incident of the boiler number 3 explosion. The Investigation Police Department, Bà Rịa Vũng Tàu Province requested expertise. The reason for the number 3 boiler explosion was a technical error and there were no signs of crime. The boiler explosion not only caused damage to Company N's properties, but also affected the assets of the paper company. The damaged properties at the paper company are in the scope of insurance coverage according to the insurance certificate. So Company N is compensated for the damage value under the law. However, Insurance P1 said that Company N delayed payment of insurance premiums, so contract number 06 and contract number 10 do not go into effect, because the last day to pay the premium is May 1, 2015, but until May 7, 2015, Company N transferred premium payment to Insurance P1. After receiving the insurance premium of Company N, the Insurance Corporation P and Insurance P1 have no idea and no written notice of late payment. The two contracts no longer effective from May 1, 2015, but Insurance P1 still receives, issues VAT invoices and reports tax on these two premiums of Company N, so Joint Stock Insurance Company P and Insurance Company P1 acknowledge that the late payment of premiums by Company N and the two insurance contracts take effect. 5. Therefore, when an insurance event occurs, Insurance Corporation P is responsible for compensation under the contract signed by the two parties. 6. As the loss in compensation, it is found that, pursuant to Article 48 of the Law on Insurance Business, it is required to conduct a loss assessment to determine the cause and extent of the loss. Then, there is a basis to determine the amount that Insurance Corporation P must pay. However, the Court of First Instance and the Court of Appeal only decided to assess the value of assets. Use that foundation to compel Insurance Corporation P to pay compensation is groundless due to Clause 15. Article 4 of the Law on Prices stipulates, valuation means determine the monetary value of assets by an agency or organization abide by the Civil Code, the market price at a price location, time, serving a certain purpose according to the price appraisal criteria. 7. On the other hand, according to the insurance contract number 06 stipulates the deduction level as follows. The deductible is the amount that the insured person incurs in case of loss occurring. The deductible level in this contract is 5% of the minimum loss value 10 million VND each loss. But the First Instance Court and the Appellate Court did not consider this agreement in the contract, forced Insurance Corporation P to pay compensation for the entire damage which it was not correct in the contract. Damaged the rights of Insurance Corporation P. 8, the insurance contract number 08. After the incident, the two parties agree to let the assessment Joint Stock Company D conduct the assessment. However, Company B has not fully assessed the losses because Company N has not provided sufficient documents. The Court of First Instance and the Court of Appeal did not consider this issue and forced Insurance Corporation P to compensate Company N when there is insufficient evidence to be unfounded. 9. Company N has not provided the evidence to prove Company N have been compensated to the third party, but the Court of First Instance and the Court of Appeal both forced Insurance Corporation P has to compensate the public liability contract number 10 and contract number 57 with an amount of 1,510,790,352 VND is unfounded. 10. In addition, the Technical Inspection Certificate of Industrial Testing Center 2 determined that the inspection was carried out before October 2013, but the Insurance Policy and Valuation Certificate determined that biomass kills produced in 2014. The Court of First Instance and the Court of Appeal have not clarified this issue, and decide to force Insurance Corporation P to pay compensation to Company N is not enough evidence, because of the above. Part 5. Rules. Pursuant to Article 337, Article 343, and Article 349 of the Civil Procedure Code, 1. Accepting the appeal number 45/QDKNGDTVC3KDTM dated February 8, 2018 of the head of the Senior People's Procuracy in Ho Chi Minh City, 2. Cancellation of the entire appellate business judgment number 01/2017/KDTMPT dated March 6, 2017 of the People's Court of Dong Nai Province and cancel all the first instance business judgment number 50/2016/KDTMST October 11, 2016 of the People's Court of Bien Hoa City, Dong Nai Province, which is between the plaintiff Company N and the defendant Insurance Corporation P, handing over the case file to the People's Court of Bien Hoa City, Dong Nai Province to conduct a first instance trial under the law. 3. Cassation decisions shall take legal effect from the date issued. Content of the case law. 4. After receiving the insurance premium of Company N, Insurance Corporation P and Insurance P1 has no idea and no written notice about premium payment. After that, the two contracts are no longer effective from May 1, 2015. Insurance P1 still receives, issues VAT invoices and reports taxes on these two premiums of Company N. Therefore, Insurance Company N and Insurance Corporation P recognize the premiums by Company N and two insurance contracts take effect. 5. Therefore, when an insurance event occurs, Insurance Corporation P is responsible for compensation, according to the contract signed between the two parties.